Welcome back to the deep dive. Ever look at a really messy legal scenario and feel a bit lost? Trying to connect the law to the facts, you're definitely not alone.
Mhm.
Today, we're diving into that exact challenge, how you navigate these complex situations, particularly when a contract seems, well, a bit shaky.
Exactly. And the materials we're working from today, they really highlight that sometimes, even when it looks like everyone's agreed, certain factors can just pull the rug out from under that agreement, make it void, potentially.
These are the vitiating factors, right?
That's the term, yeah, vitiating factor.
And the materials list a few misrepresentation, duress, undue influence, illegality too. But for this deep dive, we're really narrowing our focus, aren't we?
We are laser focused, you could say, on just one mistake.
Mistake. It sounds simple, but the material suggests it's actually quite tricky.
It really is. It's fascinating because, as the notes point out, mistake rarely succeeds in court to invalidate a contract. The legal tests are surprisingly tough.
So understanding why it's so tough and how the law actually applies it,
Yeah,
that's crucial.
precisely.
So our goal today is to walk through a practical example, one straight from the materials we're using. It's about giving you, the listener, the tools, the kind of mental framework to break down a typical scenario question involving mistake.
Yeah, how to spot the issues, grab the right legal principles, apply them carefully to the facts you're given.
And then reach a conclusion that makes sense, that's reasoned out. It's like building that legal problem-solving muscle.
Definitely. It's much more about learning that process of analysis than just, memorizing case names.
Okay, let's jump in then. The law of a mistake. What are we actually talking about here at its core?
Well, fundamentally, mistake in contract law happens when the parties are operating under some kind of significant misapprehension, something fundamental to their deal.
So it makes you question if they really consented, truly agreed.
Exactly. Was there genuine informed consent? But, and this is really important, the law is very hesitant to let someone just walk away from a deal because they made some kind of mistake.
Ah, okay. Why is that? Why the reluctance?
It really boils down to a core tension in contract law, the need for certainty. Businesses, individuals, they need to rely on the agreements they make.
Right, otherwise things would be chaotic.
Totally. Imagine if contracts could just be undone easily every time someone had second thoughts or realized they'd miscalculated. Commerce would just seize up. So the law sets a really high bar. For a mistake to undo a contract, it generally has to be fundamental, and often, it involves the other party knowing something wasn't right.
That policy of background definitely helps frame it. So the materials break mistake down into different types.
Yes, they identify four main ones:
Yeah.
common mistake, mutual mistake, unilateral mistake, and something called non est factum.
Non est factum.
Yeah, it means it is not my deed.
Yeah.
It applies in very specific circumstances, like if someone was tricked into signing something completely different from what they thought. But as the materials emphasize, for most problem scenarios you'll encounter, the key ones to focus on are common, mutual, and unilateral mistake.
Got it. Let's start with common mistake then. What's the definition there?
Okay, common mistake. This is where both parties make the exact same fundamental mistake. They're mistaken about the same essential aspect of the contract, usually the subject matter itself, or maybe a crucial underlying state of affairs. They share the exact same error.
Both thinking the same wrong thing, and if a court finds that happened.
At common law, the usual result is the contract is treated as void ab initio.
Void from the beginning.
Right, as if it never even existed. No rights, no liabilities flow from it.
The classic case the materials use is Couturier and Hasty, isn't it? Tell us about that one.
Right, so this case involved a contract for a shipment of corn. The buyer and seller both believed this corn was sailing on a ship from Salonika to the UK. That was the basis of their deal.
Okay, seems straightforward.
But completely unknown to both of them when they made the contract, the corn had actually already deteriorated during the voyage. It had overheated, started to ferment.
Oh dear.
Yeah. And the ship's captain had already put into port in Tunis, unloaded it, and sold it off because it was basically ruined. This happened before the contract was made.
So the thing they were contracting about that specific cargo of corn, it didn't even exist as such anymore.
Precisely. The court held that because the specific subject matter of the contract had, in effect, ceased to exist before the contract was formed, there was nothing to contract about. Both parties shared that same fundamental mistake about its existence. Contract void.
Okay, that makes sense. Shared mistake, fundamental to the subject matter. What about mutual mistake then? How's that different?
Mutual mistake is quite different. Here, the parties fundamentally misunderstand each other. They're talking at cross purposes about something essential, usually the subject matter.
Ah, so they think they agree, but they're actually envisioning two different things, like ships passing in the night.
That's a great analogy. They haven't actually agreed on the same thing. Their offer and acceptance don't truly align because of this basic misunderstanding.
So no real meeting of the minds.
Exactly. No genuine consent. And the effect, the contract is void.
And the case for this one in the materials is Raffles and Witchell the Peerless case.
That's the one. A contract was made for a shipment of cotton to arrive ex-Peerless from Bombay. Sounds specific enough. But there were actually two ships named Peerless sailing from Bombay carrying cotton. One sailed in October, the other in December.
Oh, okay, I see where this is going.
Right. The buyer was thinking of the ship that sailed in October. The seller, however, was thinking of the one sailing in December.
So when the December ship arrived,
Buyer refused to accept the cotton.
Right.
He said, that's not the deal I made. I meant the October Peerless.
and the court agreed.
It did. The court found there was no consensus ad main, no meeting of the minds, because they were thinking of different ships. Their offer and acceptance never actually coincided on the same subject matter.
Right.
No contract. Void.
Okay, the distinction is clear now. Common mistake. Both mistaken about the same thing. Mutual mistake. Each mistaken about what the other one means, so they're talking about different things. Which brings us to unilateral mistake.
Unilateral mistake. And this is probably the one you'll see most often in problem questions, as the materials suggest. It's where only one party is mistaken about some fundamental aspect of the contract.
Okay.
But the crucial part is that the other party either knows about that mistake or should reasonably know about it, and they proceed with the deal anyway.
So one side is mistaken and the other side spots the mistake, or really ought to spot it and maybe tries to take advantage.
That's the essence of it, yeah. The materials mentioned this can pop up in different ways, like a mistake about the actual terms of the offer or situations where equity steps in.
Let's take the mistake as to terms first. The example given is Hartog and Collin and Shields. What happened there?
Okay, in Hartog, the parties were negotiating the sale of, I think it was Argentine hare skins. Lots of them.
Hare skins, right?
And all the previous discussions, plus the general trade custom, were based on a price per piece, per skin. But when the seller sent the final written offer, they made a slip-up.
What kind of slip it?
They mistakenly wrote the price as per pound instead of per piece.
And was that a big difference?
Oh, huge. The materials note, the price per pound worked out to be roughly only a third of the price per piece they'd been talking about. It was drastically cheaper.
And the buyer?
The buyer, knowing full well about the previous negotiations based on price per piece, saw this offer with the per pound price and immediately snapped it up, tried to accept it very quickly.
What did the court say?
The court said no deal. They sided with the seller. They held there was no binding contract at that mistaken lower price. Why? Because the seller's mistake in the offer was, or should have been, completely obvious to the buyer given their prior dealings.
So you can't just pounce on an offer when you know or should know it's based on a clear mistake in the terms.
Exactly. It shows that balance again, doesn't it?
Hmm.
Between holding people to their apparent agreements and preventing one party from knowingly taking advantage of another's obvious error.
It does. That seems fair. Now, the materials also mentioned equity's role, using the case Tweekin Keong and Ors and digilinmall.com Limited.
Right, the online printer case. This is a more modern example.
Tell us about it.
Okay, so this company, digilinmall.com Limited, was selling electronics online. Through basically a clerical error by an employee, they accidentally listed a high-spec laser printer on their website for just $66.
$66? What was it supposed to cost?
The actual price was close to $4,000, $3,854, I think the materials say.
Wow. That's not just a discount. That's unbelievable.
Exactly. And predictably, word got out fast. Orders flooded in. Hundreds of people placed orders, many for multiple printers, sensing this incredible, almost impossible bargain.
And Digilinmall.
They realized the error pretty quickly and refused to honor any of the orders placed at the $66 price. Naturally, some of the buyers sued.
What did the court decide?
The court found for Digilinmall, the seller. It held the contracts were terminated because of unilateral mistake. And the reasoning, which the materials quote, is really key here.
What was the reasoning?
The court said that if a price is, quote, absurdly low in relation to its known market value, that fact alone should put a reasonable person on notice. It should make them suspect that a mistake has probably occurred.
So it wasn't just that the seller made a mistake. It was about the buyer's knowledge or constructive knowledge of that mistake.
Precisely. The court made this really interesting distinction. They contrasted legitimate bargain hunting, like finding a good deal because maybe a seller is clearing stock or needs cash quickly, with what they termed predatory pack hunting.
Predatory pack hunting.
Yeah, basically describing the behavior of knowingly trying to exploit a significant obvious pricing error. And what really clinched it, according to the materials, were online chat logs.
Chat logs.
Yes, conversations between some of the buyers were submitted as evidence. In these chats, they were actively discussing how ridiculously low the price was, saying things like, "This can't be right," and wondering if the seller had noticed the mistake yet, urging each other to buy quickly before it was fixed.
Wow, that's pretty damning evidence of their awareness.
Absolutely. It showed they weren't just innocently clicking buy. They strongly suspected, if not knew outright, that a $66 price was a mistake. So unilateral mistake.
Right.
One party's error, plus the other party's actual or constructive awareness, and often an element of trying to take advantage.
Okay, that pulls it together nicely. And just to quickly recap the effects, if mistake is proven.
Generally, a common law, as we've seen, the contract is usually void ab initio, gone, never existed legally.
Right.
But, as the Digiland Mall case hints with its discussion of fairness and equity, sometimes courts might consider other remedies. However, the materials suggest that especially where unilateral mistake with awareness is involved, like in Hartog or Digiland Mall, voiding the contract is a very likely outcome.
Huh.
The key takeaway is it's often void, not just voidable, where a party gets a choice to end it. It's treated as invalid from the outset.
Okay, fantastic. We've laid the groundwork, understood the different types of mistake, the key cases, the effects, remembering that high bar the law sets. Now, let's put it all into practice. The materials give us a really good scenario for exactly this.
Yes, this is where you get to flex those analytical muscles we talked about. The scenario involves two people, David and Sarah.
Go on.
David's a longtime coin collector. He inherits a box from a relative just labeled miscellaneous foreign coins. Not very helpful. He finds one coin inside that looks interesting, so he asks his friend Emily to take a look.
Yep.
Now, Emily isn't a coin expert at all.
Okay, not an expert.
No. She glances at a standard catalog and tells David she thinks it's a common Italian lira, maybe worth about $50. David, trusting his friend, accepts this assessment, even though he privately notes the coin looks in unusually good condition.
Right, so David now has this box containing one coin he thinks is worth $50 based on non-expert advice, leading him to believe the whole box isn't worth that much.
Pretty much. So David decides to sell the entire box as a job lot. He offers it to Sarah. Now, Sarah is also a collector, and this is crucial. She has a reputation in the collecting community for finding real bargains, for acquiring things well below their market value.
Ah, an experienced bargain hunter.
Exactly. David sells her the whole box for a lump sum, $500. As he's selling it, he mentions it contains various foreign coins, including what Emily identified as a common Italian lira. Sarah agrees to the price fairly quickly, buys the box without really inspecting the contents thoroughly herself. The materials say she relied partly on the low price for what seemed like a potentially large collection.
Okay, the deal is done. And
then Sarah, later on, takes that specific Italian coin David had mentioned to a proper specialist for appraisal.
And the specialist says?
The specialist tells her it's not a common $50 lira at all. It's actually an extremely rare variant. Its true market value, around $15,000.
$15,000 from $50. Wow, and she paid $500 for the whole box.
Precisely. A massive, massive difference. So, understandably, when David finds out, he's horrified and wants to undo the sale. Sarah, equally understandably perhaps, says, nope, a deal's a deal.
Okay, so the core legal question, as the sample analysis and the materials frames it, is this contract for the sale of the coin collection legally binding, or can David get it set aside because of mistake?
That's the issue. Now we apply our framework.
All right, let's put on our analytical hats. Using the types of mistake we discussed, where do we start? How about common mistake? Could that apply here?
Well, following the analysis and materials, common mistake seems unlikely. Remember, common mistake needs both parties to share the same fundamental mistake about the subject matter.
The subject matter here is the box of miscellaneous coins, right?
Right. David was clearly mistaken about the value of one specific coin inside the box. But was Sarah laboring under the same fundamental mistake about the entire box? Doesn't seem so.
She wasn't buying it specifically thinking this is a box of only common low-value coins, was she?
Probably not. The material suggests she bought it as a box of miscellaneous coins, hoping perhaps for a bargain based on the low price and her general approach. David's mistake about the lira was specific to him. It doesn't look like they shared the same fundamental misapprehension about the overall nature or value of the entire box as a collection.
Okay, so common mistake is probably out. What about mutual mistake?
Mutual mistake also looks unlikely here. Remember Raffles and Winchell House, the parties being at cross purposes about the subject matter
Of
itself?
the two ships, yeah.
Was that happening here? Did David intend to sell one box and Sarah intend to buy a completely different box? No.
They both agreed on that specific box for $500.
Exactly. David intended to sell that box, Sarah intended to buy that box. They weren't mistaken about the identity of the thing being bought and sold.
Mm.
The disagreement is about the value of the contents within that agreed-upon box, not the box itself. So no mutual mistake.
Okay, so if common and mutual mistake don't seem to fit, we're left with a unilateral mistake. The material suggested this was David's strongest argument.
Yes, absolutely. Let's break it down. Was David mistaken? Undeniably. Thinking a $15,000 coin is worth $50 is a massive mistake,
Ah.
and it was fundamental to his assessment of the box's value and his willingness to sell for $500.
So the big question for a unilateral mistake then becomes, was Sarah aware of David's mistake? Or, crucially, should she reasonably have been aware of it?
That's the nub of it. And this is where we need to scrutinize the facts about Sarah and the circumstances of the sale very closely.
What facts point towards her potential awareness?
Well, the materials flag several key points. First, Sarah's own background. She's an experienced collector with a known reputation for sniffing out bargains and buying below market value.
Okay, so she's not naive in this market.
Definitely not. Second, how she bought it. Quickly, without a thorough inspection herself, relying partly on the low price for what looked like a substantial collection.
Hmm.
Third, David actually mentioned the specific coin he thought was just a common Italian lira. He flagged the very item that turned out to be incredibly valuable.
Right. And how does the digital animal principle about the absurdly low price fit in here? $500 for a box of miscellaneous coins doesn't sound absurd on its own.
It doesn't on its own, no. But the analysis applies the principle differently. It's not about the $500 price in isolation. It's about the relationship between the price paid, $500, and the actual value of the contents, specifically that one coin, $15,000.
Ah, so the discrepancy is absurdly large. A single item worth 30 times the price paid for the whole collection.
Exactly. That's a huge, huge gap. And this forms the core of David's argument for unilateral mistake.
So the argument is, given this massive potential value difference, plus David specifically mentioning the coin he misidentified, plus Sarah's own expertise and reputation as a bargain hunter.
Could it be argued that she should have suspected something was wrong? That a reasonable collector in her position, hearing about a specific coin being dismissed as common but paying such a low price for the whole lot, should have been put on alert?
Put on inquiry, as they say. Should she have realized David might be seriously mistaken about the value, especially concerning that specific coin he mentioned?
Precisely. Her experience cuts both ways, doesn't it? It might make her better at spotting bargains, but it also might mean the law expects her to be more alert to potential mistakes by the seller, especially when the price seems disproportionately low relative to a potential key item mentioned. It echoes that vigilant mall idea about not knowingly taking advantage of a significant error.
Okay, so David's success really hinges on persuading a court that Sarah either actually knew he was mistaken about the coin's value, or that the circumstances, the price, his comment, her expertise were so glaring that she constructively knew she should have known.
That's the battleground, absolutely. And looking at the overall conclusion in the materials analysis, common mistake, unlikely. Mutual mistake, unlikely. Unilateral mistake is David's best shot.
And if he wins on unilateral mistake, if he convinces the court about Sarah's awareness, what's the likely outcome for the contract?
Based on cases like Hartog and Shields and the implications from Digital Mall, if David successfully proves Sarah's actual or constructive awareness of his fundamental mistake about the coin, the contract for the sale of the box would most likely be rendered void ab initio at common law.
Back to square one, as if the deal never happened.
Pretty much. While equity always offers potential flexibility, the materials suggest that in a clear case of unilateral mistake, with awareness like this potentially is, voiding the contract is the strong probability.
So if we were summarizing the advice for David based on this analysis,
It would be. You have a viable, potentially strong argument to have the contract set aside based on unilateral mistake. Your success, however, depends entirely on proving Sarah's state of mind that she either knew or objectively should have known, given all the circumstances, that you are operating under a significant misapprehension about the value of that rare coin when you agreed to sell the box for only $500. The huge value discrepancy is your key piece of evidence here.
That's a really clear application of the law. So this deep dive has really taken us from that broad idea of vitiating factors, narrowed it down to mistake, drilled into the three main types: common, mutual, unilateral,
Looked at the key cases like Couturier, Raffles, Hartog, Digel, and Mall.
and then walk through applying that whole structure step by step to a practical scenario: David and Sarah's coin collection problem.
And hopefully, by doing that, you can see the method more clearly. When you get a scenario question, first, identify the potential issue here, mistake. Then, define the relevant legal rules, the types of mistake, the tests. Cite the key authorities, the cases.
Then apply those rules really carefully to the specific facts you've been given. What did each party know? What did they think? What was said? What wasn't said?
Exactly. Compare the facts to the cases. And use that detailed analysis to build towards a reasoned conclusion. Is the contract likely valid? Is it void? Why?
And it brings us back to that policy tension we started with, doesn't it? Certainty versus fairness. Mistake is hard to prove because of certainty. But when the facts really shout that one party unfairly took advantage of another's clear fundamental error, the law, especially through unilateral mistake, provides a potential way to achieve a fairer outcome.
It really shows the law trying to strike that difficult balance.
Okay, before we wrap up, here's a final thought for you to chew on, something to help solidify your understanding. How do you think the analysis of David and Sarah's situation might change if Sarah wasn't an experienced collector? What if she was a complete novice buying her first box of coins with no reputation and zero knowledge of coin values?
Ooh, good question.
Or what if David had sold the box for $500 but had never mentioned that specific Italian coin, just sold it as a box of miscellaneous foreign coins as is? How would those changes affect the argument about Sarah's awareness, actual or constructive, of David's mistake?
Thinking through those variations is a really good way to test how well you've grasped the critical role of awareness, especially constructive awareness, in unilateral mistake. How much knowledge should the law attribute to the non-mistaken party? It often depends heavily on those specific facts.
Exactly. Small factual differences can lead to very different legal outcomes. Something to keep in mind as you tackle your own scenario questions. Happy studying. Until the next class.